Hello. In this recording of our Justia webinar, Flying Solo Checklist 30 Things You Need to Do to Avoid Malpractice, Mark Basingthwaite shares with the audience everything they need to know to protect themselves and their clients from potential malpractice claims. This program highlights common malpractice and ethical concerns lawyers face and shares practical tips lawyers can use to responsibly address those concerns. Remember, if you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Well, thank you, Nina. It's a pleasure to be here. Now, before I get started, let me just share my screen and get the slides up. Okay, so in my role as risk manager here at ALPS, we are primarily a solo small firm insurer all over the United States. And although I've worked with firms of all shapes and sizes, I thought it'd be fun to sit down and just go through a checklist of the things that as a risk guy, I really think are most important. So that's what we're going to do today, and just kind of rock and roll. So here we go. Oh, well, we already did my introduction. We'll skip that. Okay. With an eye toward maintaining client confidences, keep all spaces clients have access to tidied up. I got to tell you, this really is a more significant thing than you might at first guess. As you've heard, I've been in 1,200 plus law firms in my time here at ALPS. I have walked into some places that were absolutely stunning. I'm not kidding you. Some of them I would say were museum quality. One was actually a law firm art gallery, one of the most interesting firms I've ever been in. But I've also been in a lot that are quite the opposite. I've been walked through on the way to a conference room, cluttered halls, torn and dirty carpets, and furniture lined up on the sides and just junk. And you get into the conference room and it looks like an old attic. There's just stuff everywhere. That leaves an impression with people, particularly if this is the first time they're walking into a firm. I've sort of continuing on with this idea of first impressions. I've walked into reception areas where the receptionist just treated me like she was a bother. Feet up on the counter, chewing gum, slovenly dressed, reading a romance novel, and looks at me like, here's somebody else. It's like, really? Again, that has consequences. So I would encourage you to periodically, look around your space. What does it look like? Check the reception area. Do people feel relaxed and, comfortable in the space? First impressions matter. When I see all these messes, I sit and say, I would wonder if you have time to actually work on my matter, because you certainly don't have time to keep up with the place, to keep it tidied up, etc. So if you agree, again, take some time to prioritize this. It's going to be easier, in my mind, to establish an effective and trusting attorney-client relationship if a potential new client's first impression is very much a positive one. So food for thought. Run a preliminary conflict check at first contact. I will share as a risk guy with a malpractice insurer, and we are again nationwide. The conflict claims are a very, very hot area of malpractice. It is not a frequency piece, if you will. It is the severity piece. These claims often boil down to greedy attorney putting his or her financial interests above somebody else, and juries can have field days with punitives, and it just gets to be very, very messy. So you want to take these conflict issues pretty darn seriously. I think conflicts are partially a problem because memories are short. The preliminary check is really about trying to help identify these potential conflicts at the very beginning, so that we're not unintentionally tainted as one problem. And think about, model rule 1.18, duties to prospective clients. We can be tainted if we obtain during intake substantive information that could be used. So that's we want to avoid that. So, do this conflict check up front. Before you get any substantive information, you want to ask, who are you? What type of matter is this? Who are the key, adverse parties, whatever it might be, depending on the type of situation we've got going here. Run that through before you get any information. And if there's a hit, you decide what to do. Do we still go in anyway if you can? But I don't, again, want to be unintentionally tainted. Let me share one real malpractice story. We had a situation where an associate at a firm had a preliminary meeting with someone about a potential divorce. And this was going to be a significant divorce. There was, maybe 25, 30-minute conversation. But in other words, it was a substantive discussion, a lot of information obtained. And for whatever reason, no attorney-client relationship was formed. And, off we go. Wasn't all that long had passed before one of the partners accepted a divorced client and brought this matter in, and it was the other side. No one was aware because, again, the potential conflicts, here's another little tip for you, they were never being tracked. If we say no to these potential, preliminary kinds of things, we don't track these names. You have to now with Rule 1.18, that is relevant information if you've had a substantive discussion. So, and long story short, a malpractice claim did arise out of this situation because the firm was conflicted out and there was a bit of a loss paid there, all for want of this process. So, it's worth doing. I'll just leave it at that. Okay, let's continue on. If we do this preliminary conflict check, no hits, and we decide to have the preliminary meeting and then just talk through all this stuff, we need to run a second and more thorough conflict check prior to saying yes and accepting the matter. I will share, particularly in smaller firms, the database is there, and firms are fairly good about using it if there is this mental hit. Basingthwaite's ringing a bell and I can't place it. Let's go look. But if there's no mental hit, they don't run this check. Again, memories are short. You really need to be consistent about following through with this. I will also share that my bigger concern is in terms of a formalized process, is that, again, in the solo small firm space, we're less likely to see, if you will, we missed that name as we do the conflict check. We found the name, and it's the resolution process. It's the problem. And sometimes money drives ethics. So I really encourage you to take some time, if we have a hit, to really try to sit down. And if unless you are a true solo, talk with your partners, and that's sit down. You could advocate, this is why I think we should take this matter and why I don't think it's a problem. But others need to help provide some clarity, because sometimes when money is on the line, and a lot of it, if we get to say yes, can be, again, it just colors our perspective of we try to rationalize our way through this, and you really don't want to do that. So one other thing that I will share, I've had firms say, particularly, for instance, you're all personal injury, so we're always on one side. We don't need to worry about these conflict checks. That's not so true. Here's another situation. A personal injury firm accepted a matter, and it's a personal injury matter. They get rocking and rolling on it, and maybe 6-8 months later, another matter comes in. It happened to be a workplace injury situation, and they took that matter on as well. The further they get into the work injury situation, they realize, okay, we want to sue this entity and the owner and whatnot. And that turned out to be another client. It was a personal injury matter they took 6-8 months before. Well, they can't sue a current client, and boy, that got to be a real mess. And again, it turned out to be a claim. So caution, this is very, very important to do. Number 4, determine if the prospective client can actually afford your services, and clearly identify the prospective client's goals and objectives. In my mind, in terms of determining if the client can afford your services. This really isn't optional. This is your responsibility. And sometimes lawyers have problems talking about money. It's just difficult. We need to learn how to do it, okay? There's a difference between, here's my hourly rate and really explaining, trying to guesstimate at least what the range is and explaining, what to keep it on the lower side and what might take it to the higher side, so that the client can make informed decisions about all of this. Okay. Look at it this way. Would you go into a car dealership and buy a car based only on knowing what the monthly payment's going to be and have no idea how long this is going to go? You see where I'm going? I can afford this monthly payment, but wait, this goes on for 10 years. That's going to be a problem. I don't have that kind of money. So make sure. I would also just encourage you to listen and try to identify what are the goals. I can share one story. I was involved in a real estate transaction a number of years ago on some pristine property in the northwestern corner of Glacier National Park out of Montana. And things weren't moving and going the way I thought they were or I thought they should, because I'm focusing very much, we want to get this much money. It's all about the money here. Turned out it wasn't all about the money. The seller was a person who had spent a lot of years on the property, literally cleared this land by hand, built a homestead cabin on it many years ago, and then a very nice, beautiful second cabin on it. And he wasn't going to give it away, but what was more important to him was finding someone that would respect and love the property and care for it the way he did. And once I kind of figured that out, boy, some things really moved pretty quickly, and we got where we needed to get to. Another situation was involved in, I was at a mediation, and it was a malpractice mediation. And, again, I'm focusing on money. We want to try to get our insured out of this with minimal layout if we possibly can, but you want to be responsible with how we go through this. And, finally, and thank God we had a really good mediator. He kind of pulled me aside a little bit and started to say, you might be interested in hearing some other things. I'd encourage you to try to change your perspective here a little bit. What seems to be important to the other side is just an apology. And again, all this is about just questioning my assumptions. And I encourage you to look at it the same way. Took a little time. We actually ended up having the lawyer walk in, and he really did give a very sincere apology. And the person was very appreciative and just felt validated. And I kid you not, that was the end of it. The mediation was over. There was never a payment made. All the person wanted was an apology. So, it's important to just take the time. Sometimes we think we know this is how it should play. This is how it always plays. No, take the time. Clearly identify how you can best help your client get to where they want to go. Okay? Don't run with assumptions. Okay. Number 5, say no if you don't have the necessary time, resources, or expertise to competently handle any proffered matter. This is a big one. Again, I'd encourage you to ask some questions. I'm thinking about things like, do you have the time to take this new matter on and give it your full attention? Be realistic here. Remember the rules, the rules of professional conduct. Every client expects, deserves your full attention. That's all about competency and due diligence, 1.1, 1.3. If that's not possible, you really need to say no. Do you have the necessary expertise and experience to handle a matter? If yes, hey, that's great. Take it on. If no, can you responsibly come up to speed? Work with a trusted colleague, research the law, that kind of thing. And will the client be good with that? If it's a contingency fee matter, do you have adequate funds to take it on? New matters often look their best on day one, and unlike, fine wine, they don't always age well. And a quick settlement doesn't end up happening. You want to make sure you haven't placed yourself in a situation where case management decisions are going to be made in light of your economic realities. I mean, I call that a conflict of interest. We don't want economic realities driving this. We want your professional judgment driving. Okay. If this is a significant matter, is your firm properly staffed and equipped to take it on? I get sometimes these big cases can come in and they can be financially very rewarding. They can be intellectually very stimulating and exciting to be involved in. I understand that. But if you don't have the ability to take that on and handle all the things, for example, if literally a truckload digitally or, in boxes of documents are dropped at your door, can you handle reviewing all of that? Now, sometimes lawyers will say, I've asked this question, I've thought through this, I've talked to my staff. The answer is yes. Great. God bless. Rock and roll. But don't forget about this. When we say, do you have the necessary time and resource and expertise to handle this? You also need to be thinking, in addition to everything else I've got on my plate. Sometimes we see they handle the big matter really quite well. But it's three smaller things, two of which had SOLs, statute of limitations dates that are about to run or do run, because they forgot about them. They're so wrapped up in taking care of this overwhelming thing because the truckload of documents came, and it's the smaller, less important stuff that just goes off the radar. You have to think all the way through this. Okay? Don't ever dabble in practice areas you are not competent in. Really, folks, there is no such thing as a simple will, a simple, personal injury matter, basic contract, or any other type of matter. It's often a situation where we don't know what we don't know. I don't want to see you shooting from the hip. I mean, if you want to broaden your horizons or go in a different direction, hey, again, God bless, mentor, co-counsel, research the law. There's a lot of ways to come up to speed, but you got to come up to speed. Another real claim. We had a situation a number of years ago, and this is one of my favorite stories sort of on this topic. A lawyer was a personal injury guy, but had a couple of friends, and this happened to be in Las Vegas, which is a part of the story. Had a couple of friends that were pretty successful doctors, and these guys apparently had a little extra money sort of burning a hole in their pocket, and they wanted to make an investment, and they committed to purchasing a business, and it was one of these businesses that sell photos, helicopter shots of the Strip and professional photos, that kind of thing. There's no money in the helicopter shots, by the way, and money's in professional photos or celebrity photos. But they wanted this reassurance, so they go to the lawyer and say, "Hey, we're excited about this, but boy, would you mind? Do you have a little time? Could you take a look at this contract?" And they just, again, wanted some reassurance. Guy says, "Look, this isn't my bailiwick, but sure." He learned there was a standard document. He said, I'll see. And he looks at it briefly. "Hey, everything looks good to me. Hey, good luck. I'm so excited for your couple." Well, they got taken. There's a law in Las Vegas that is not widely known that deals with the transfer of rights to sell celebrity photos, and a standard basic contract would be silent on that point, which was why it was in use. These guys lost a couple of $100,000 and wanted their money back from the lawyer, and they did get it. He didn't know what he didn't know. So I'm going to share. This is, I wouldn't say, again, this is hot, hot, hot on fire, but this is slow and steady. Year after year after year, we see these dabbling claims. They're fairly common. Find time to take care of yourself and your support system. If a state of well-being is absent in your personal, professional, financial, spiritual, family, in all aspects of your life or in any aspects of your life, that's a problem, because it increases your risk for stress, burnout, indecisiveness, apathy, forgetfulness, potential loss of support systems, and it just goes on and on. And they can evolve into other types of impairments. And these are the true causes of malpractice. You can look at a lot of data, and around the country, the ADA puts a lot of stuff out every 4 years, and it's worth looking at. But it tells you what happened. Statute was blown, matter was neglected, etc. It doesn't tell you why. This is why. This is why. Take care of yourself. Eat right, exercise, nurture your support systems, etc. I can share just to kind of get your attention. And again, unless you're a true solo, but if you're in a firm, we are partners keepers. Remember Rule 5.1? Was a situation where this is a firm. It's structured in a way a lot of smaller firms are. I would call them firm in name only. We have silos of our individual practices, and it's not really operating as a full firm in every shape or form. And one of the attorneys had chronic depression and was coming in and talking to clients and chatting up the staff and on the surface behaving fairly normal. But he had gotten so depressed, he could no longer make any decisions. He was hiding files in the trunk of his car, behind furniture, under rugs. When this all came to light and blew up, we had 22 active, viable claims as a result. And, the firm's going, what? It's not our fault. Excuse me? You came together as a firm. You're going to sink or swim. We need to, prioritize. And I guess a side lesson would be, let's look after each other. If you see some indications of some trouble, act on it. And it's not firing. It's calling, lawyers assistance programs. It's talking, Mark, are you doing okay? You look like you're struggling. What can I do to help? It's about walking with this person back to a state of health and working with them. And sometimes even just acknowledging that they have a problem can help them move. So food for thought. Okay. Document all declinations. If a cold call, comes into the office, hey, do you guys do bankruptcy? The answer is no. I don't care. I'm not going to document that. This is a short, quick call. We're done. But if there is any kind of substantive information shared or documents dropped off, we'll look at this and see. And, at the end of the day, we say no. You need to document the declination with some type of non-engagement letter or something that's even hand delivered. Potential divorces, I get it. You don't want to send a letter to somebody's home and the unsuspecting your spouse opens it. Oh my gosh, what's this? We've had that claim. So it comes up every once in a while. But you hand deliver this stuff. But you do want to document the declination. It's just to make sure that the potential client you were interacting with you're confirming, so that no assumptions are in play, that there's no attorney-client relationship and you have no obligation to move forward with anything. It's kind of, thanks, we're here in future, but we're not taking this matter on. Now, one important side note, sometimes lawyers will put some legal advice in these things, and that's okay. Or they may even have a little advice in terms of shared during the intake process, even though there's no attorney-client relationship. If you give any advice during that conversation or in these letters, a non-engagement letter doesn't cut off your exposure for that. Make sure your advice is accurate and you have the information you need to give that advice. Even in non-engagement letters, we at times see you have a statute running and they'll put the date down and we've seen it too long and too short, and claims will come out of that because they're going to rely on that. Okay. All a non-engagement letter does is document that you have no obligation to do anything after, but you're going to live by whatever advice you give. So just a caution. Put all fee agreements in writing. This is extremely, extremely important. If there's ever a dispute, if you don't have it in writing, in terms of fee dispute, if you don't have it in writing, don't pursue aggressive collections. I'm just saying it's not going to work out well for you. I just want to make sure we have established realistic expectations and it's documented. These are all about assumptions. So I understand if I'm the potential or the new client coming in, I understand what this is going to look like. I understand what my expectations are, or what your expectations are in terms of the fee you'll be earning. Um, I will also have an explanation of, the things I'm going to be responsible for, out-of-pocket expenses, filing fees, court costs, etc. Let's make sure we're all on the same page. We do see, and hear about, more than a few situations where clients and attorneys are disagreeing about what's owed. And you'd be surprised how often there's little to no writing. And all I can do is say, I would walk away. It's just, you have an obligation to document this. If you didn't, that's your loss. Document scope of representation on every matter. Notice that I did not say every new client. I said every matter, okay? I hear all kinds of excuses. This isn't necessary. It takes too much time away. It'll be offensive. Think repeat work. We're trying to keep costs down. I get it. That's all well and good until your work is questioned. And, memories can be short, okay? I really want you to think about writing to your audience. So let's look at the repeat client, long-term client. That's a common excuse. I don't want to send out this, 8-page contract. It's offensive. Okay. Look, a letter of clarification, a confirming email, write to your audience. Hey, it's great to see you again today, Mark. Of course, I'll be happy to help you with this contract issue at the dealership. Regular rates apply. Please let me know if there's anything else I can do for you. Say hello to your lovely wife, and I'll see you next week at Rotary. I'm writing to you're writing to the audience, me. You know who I am. We have this relationship, and that may work. But we have this document that confirms your role. What is your scope? You also want to start to think about documenting what you're not going to do, even in full service situations, as opposed to just limited scope representations. Let me give an example. There was a lawyer that agreed to take on a matter for $75. And all it was is really someone wanted to be reassured that they have a good case and the attorney that they have selected was a good attorney. That's just sort of like the second opinion situation. Took $75. There's, a little note, $75, but there's really nothing else there. There's just this record that this thing happened, not what happened in it, not what was said. Did say, hey, this looks good. The primary attorney ended up blowing the statute and happened to be uninsured. And so it's a hunt for deep pocket. And there's a claim that comes around, and now it's framed as, well, I sort of thought you had some responsibilities here. I hired you, and they sort of frame it as a co-counsel. And there's no documentation that you put any limitations here. I will share again, there was a loss paid out there, and it was not insignificant. So really be careful about and clear in documenting your scope. It is extraordinarily important. Think about, if you're going to handle a personal injury matter and there's a work comp component, you don't do work comp. I would document that. Hey, you're going to do a full service divorce. Are you going to, or you have a large settlement in personal injury matters, are you going to advise on tax consequences? If not, I would strongly encourage you to say, no, I'm not going to do this. I encourage you, issue spot. I encourage you to hire a CPA or whatever we need to do to take care of this, but I am not going to do that. Okay. We need to be very, very clear. Okay. Remember who hired who and act accordingly. I will share that over the years, I myself have hired a few lawyers to handle some legal things for me. And I can say firsthand, this is a problem. And what I'm talking about is communication. Okay. You are in someone's employ. You have an obligation to keep them informed. And oh, by the way, 1.4 communication says so. Okay. Don't take this lightly. Remember, and this is one of the most common disciplinary complaints nationwide. It just happens over and over and over. My lawyer isn't talking to me. My lawyer won't respond or isn't keeping me up, That's crazy. You know, if you continue to forget who hires who, it's going to be ever harder to stay in business, if you ask me. You're to advise your clients about the legal and practical aspects of any given matter. You are to identify and evaluate alternative solutions, point out the positive and negatives of each. The goal here, again, think about 1.4, is to enable your clients to participate intelligently in decisions concerning the objectives of the representation and the means by which they are to be pursued. That's what the clients get to decide, right? The objectives. What are the outcomes? Okay. So time to respond to requests, forward copies of documents, keep clients informed of all court dates, all filings, and all offers to settle or mediate. I just had a phone call yesterday afternoon where a lawyer just called in and said, I think I screwed up. I was given permission to make an offer, a settlement offer, policy limits, but and I just accepted it, but I really didn't clarify whether or not my clients wanted to settle with policy limits, and turned out they did, and they were most upset. And so here we have a claim. You can't run with assumptions. You need to tell them every time. They need to be told the good, the bad, and the ugly. Even if you've made a mistake, you need to tell them that in terms of, I blew a statute. Now, on this one side note, please don't fall on your sword. Don't run to the client. I blew this statute. I told you this case is worth $500,000 and my insurance, I'm going to contact them tomorrow, make sure you get every cent. You may have just completely jeopardized coverage because you're in breach of contract. Always call your carrier first. They will advise you about what to say. You can't admit liability contractually. Okay. You just can't do that. So, next, what do we got here? I'm checking my time and trying to make sure we're good to go. Have a second set of eyes. Check all critical deadlines for calendaring accuracy. I shared conflicts are sort of the hot piece in terms of severity. Calendaring missteps year after year after year are the frequency piece. This is where the a majority of the money is being paid because there's just so many of these claims. So I just want to underscore the difference between independent and redundant calendars, independent redundancies and just redundant. Lawyers, I have found over the years, again, on the consulting side, lawyers are pretty good about redundancies and for good reason. But carriers aren't focused on redundancies. We're focused on independence. Let me share why. There's lots of ways to get there, but let's pretend for a moment. You're a solo lawyer. I'll be your staff person, legal assistant, paralegal, it doesn't matter. It's just the two of us. Here's what we do. I sit down and I put everything into my my daytimer's desktop. I take that calendar and I put entries into the digital tickler system, the cards, whatever it might be. I sit down at your desk and I put everything into Outlook and it syncs to your Droid. We've got now 4 calendars. I mean, that's the thinking. No, we have one calendar. It's just 4 copies. What if I make a mistake? I've simply copied that throughout. Okay, so you need to think about calendaring as a quality control process. You could do second set of eyes. You could have, and there are a variety of ways to get there. Here's one. I do everything I do in paper. Independent of my efforts, you take original documents and you calendar into Outlook. So I'm calendaring into my daytimers. You're calendaring into Outlook, and you want to make sure you are doing completely independently of me. We'll periodically get together for calendar review every couple weeks, months, whatever your practice needs dictate. And again, we're looking for the mistakes. Mark, you have July 4th. I have September 4th. Who's right, who's wrong? And let's figure that out, solve the problem. Another way to do it is I still do everything I do all the way through, but independent of my efforts, you look at original documents and you make sure I've gleaned all the important dates and entered them accurately. And then you do the checks, the initials in and all this stuff. Now, one caution here. This process that I've just described, where you review everything I've done, was in play at a firm. And after about 18 months, the lawyer finally said, Mark really knows what he's doing. I don't need to worry about him. He is very competent. Has nothing to do with competency, okay? It's quality control. Here's what happened. He stopped monitoring the example, but what the real person was doing, stopped monitoring. And eventually a call came in, something along the lines, Mark, Mom just had a stroke. It's not good. You and Kathy need to get out here ASAP. Oh my gosh. I'm doing everything as quickly as I can to try to minimize the impact of this unexpected departure on the workflow and all that's going on at the office. I'm worried about airplane tickets, the dogs, who's going to care for the kids. It goes on and on and on. Life is on full speed, right? That's when I make a mistake. Now, we're not going to find that blown statue, or we're not going to find the mistake till the statue's blown down the road. Real clean. So I encourage you to think, if anyone ever created or ever made a mistake in a calendaring entry, do you have a process in your firm that would catch that? If the answer is no, I encourage you to do something about it, to try to fix and figure that out, okay? We need to make some adjustments, okay? The final comment, if you happen to be a true solo and have no staff, I wish it's, well, here's the magical thing we could do. There is no sort of magical process here. All I can do is say, please be intentional about it. Set aside a block of time. It might only be 10, 15 minutes, and focus on calendaring. No interruptions, no call, just, focus. And then, maybe the next day, or if you do this first thing in the morning, the end of the day, just double check your work. I would tend to do it the next day because I like a little sleep, fresh eyes, if you will. It's your own second set. But you want to come at it fresh. And again, when your mind's a little clearer, and just double check can really make a big difference. Okay, use reminder dates for all critical deadlines. Again, actually entering the date of a task to a calendar doesn't do much if the calendar is not going to be reviewed well in advance, So we really like reminders put in. It helps prevent these torpedoes that can come. It's fast approaching deadlines, statute of limitations, filings, discovery deadlines, et cetera. Let's put multiple reminders, 30, 60, 90 days out so that we have time. And here's one little interesting rule that I've come to like over the years too. Let's say we have a critical deadline that's going to be the 30th of whatever month it is. Don't run the 30, 60, 90 off that actual deadline. So if the actual deadline's the 30th, go back to the first and then run your 30, 60, 90 off that. You're building in this cushion, okay? And that can be really, really important. I never want to get into that cushion because, I have another slide coming up that'll tell you why. But you're well advised to sort of go that route. Establish a file review process to make certain no file is ever forgotten about. A lot of lawyers don't want to do a file review. They see it as a hassle. Well, one of the things you could do is call it client review, and I'll sort of explain what I mean by that. But really the goal is to make sure that no files, is ever forgotten about, okay? A real claim, a situation where a lawyer had a client who was very, very wealthy and lots of business things going on. And he walked in the office one day with a small file and said, I'm sort of cleaning up my office. This involves a collection matter with a huge, I think it was a sort of hotel casino situation. And I don't think I'm going to do anything about this, but again, I'm just cleaning things up and I'd like you to hold this and just keep it here just so I know where it is. Fine. For whatever reason, that file ended up getting filed away without anyone looking at it and anyone making any notes about it. To make a longer story short, this gentleman unexpectedly passed away. And while he was not interested in pursuing the collection situation, the executor was, and came in and asked about this file. And they pulled it and realized that a statute had blown. And it was a major loss. And, all for one of file review. All somebody had to do was just put something in the calendar. So I encourage you, if there's no date in a calendar on a given matter that you're looking at, I encourage you to put a file review date in. Practice needs will dictate how frequently that needs to be, 30, 60, 90, whatever works for you. But you want to make sure you have something to get you back, okay? Now, sort of this client review process, sometimes they'll pull a file and there's nothing going on and we're good. We'll set another file review date. But they'll reach out. Mrs. Smith, just letting you know, we're still waiting for whatever is from the other side or from the insurance company or whatever it might be. This is really pretty normal. We'll check back next month, but if you have any questions, feel free to reach out. But you're kind of sharing, you're in good hands with us. We haven't forgotten about you. And that can prevent these calls from coming in. What's going on? What's going on? Because they know you will consistently reach out and reassure. Think what that does in terms of loyalty to your firm, to potential referrals. These folks really look out for me, and that I feel like I'm in good hands. So that can be a client review process, but the goal is, again, not to have that file forgotten about. Have a backup copy of the calendar offsite or in the cloud. I just love this photo because to me, that's the cloud. It's a humorous inside. To me, it's just like, that's the cloud. I just encourage you again to have a backup copy of the calendar and really everything else in the cloud. But one of the simple reasons why is what would happen if you had a fire tonight or got hit with ransomware? And I mean, nothing is available in the morning and may not be for some time. Disasters happen, okay? If you can't get to your calendar, that can be a problem. I have talked to lawyers that said, we thought for years and years, well, we could just go to the courthouse and rebuild from there. And they'll say to me, Mark, tell everybody else, that's a false sense of security. It takes months and you never know if you get it all. And we lost a lot of sleep worrying for months. Have a backup calendar off-site or in the cloud. These crazy things happen. And if you don't have the ability to even know basically what crises or potential crises you need to address, again, you got a problem. So I'm going to leave it at that. Okay, what's next? File suit well in advance of the actual deadline, knowing that sometimes unexpected things happen. This gets back to where I was talking about, let's build our reminder dates, off a pretend date that's 30 days before. I know there are lawyers that are early filers and some that are late filers. The early filers just want to get it done. The late filers think, well, this may impact the ability to settle if we file early. Okay, I don't care which side you're on. I really don't. God bless you either way. They're both good. As long as you don't blow the statute as a late filer. And, I never want to get into 30 days. Last minute filings are playing with fire because, again, there's no time to address any problems that might arise. Unexpected things like illness, computer failure, the discovery of an incorrectly calendared date, office vandalism, weather events, accidents on the way to the courthouse, ransomware, on and on. All of these examples that I've just shared are real. I mean, claims, not real. Okay, of course, we know people get sick, but these are real claims, okay? Could be as simple as you've discovered at the last minute you named the wrong defendant. You know, you need time to fix that. So never allow it to get within 30 days. Build that 30, 60, 90 off a pretend date, 30 days out, to give you that extra little cushion. Can be worth so much in terms of time to bail yourself out of a mess. Make sure all calls are returned promptly and that the client is always aware of the good, the bad, and the ugly. Again, and I just want to underscore this, it happens so much. Remember who hired who. And when we talk about this, the bad and the ugly, one of the worst things gets back to these claims. I think we made a mistake. Do we have to tell? Yes, the ethics opinions are very clear. And I can share a story in a moment. Call your carrier first. Don't fall on your sword. Call your carrier first. Let them guide you and work with you through this conversation. Okay? It is not extremely common, but it's also not extremely rare, where dates will get blown and lawyers will try to fix it themselves. And they'll go beyond claims repair, working with the carrier. They'll say things like, Mrs. Jones, I'm sorry we blew. I'm sorry. It's been a little while. Hey, I have some good news. This did settle. I know we talked about $100,000, but realistically, this came in at about 70, and that's really, we've got a good. And what's happening? He's hiding it and paying 70,000 out of his own pocket. You'd be surprised how often this kind of game playing, and I understand why they do it. They're so embarrassed. They're so, oh my gosh, I can't believe. And I get it. Don't do this. If you're not sharing, you're first off, you're lying to your client. You're hiding a claim from the carrier. What ends up happening in some of the, more than just a few of these types of situations, the lawyer ends up not having any coverage for a claim, and there will be a claim out of it, and they end up losing their license. This is not the way to go out. So it's back to, let's keep folks informed. And I'm kind of focusing on the ugly there, but I could tell one other quick story. I worked with an interesting lawyer in the Southwest a number of years ago who was a very high-profile divorce lawyer and would only take on clients who were women of very wealthy men. And that was his business model. The problem was, and pardon me, I'm really not trying to stereotype here. I'm sort of sharing his perspective in words, the way he didn't like having to deal with, in his mind, high maintenance women, which all these women were in his mind. And they were constantly trying to call and talk to him. He was never returning phone calls because he just didn't want to. I spent an hour with him in a private discussion at one point. And after that hour, just during that time, there was something like 50 to 60 phone messages from his clients. And I'm going like to the staff, is this normal? This is crazy. And they said, oh yeah, this is really normal. What he has done, this is what they're telling me, is he will wait till the end of the day and respond to the person that, if you will, screamed the most during the day. And all the clients figured that out. And it was just a mess, absolute mess. End of a long story. He had, I think, 3 to 4 claims come out of that. And they were, and as well as disciplinary complaints. Suffice it to say, there were some losses and some sanctions, and he ended up not, let's just say, forced into early retirement might be the way to describe that. Didn't need to be that way. Who hired who, okay? Oh, by the way, find time to take care of yourself and your support systems. Learn to say no. Say no to additional work that's out of your comfort zone. Say no to work that you don't have the time to take on. When you say yes to things you should be saying no to, what happens is procrastination comes into this, and it invites relationship problems. Who isn't going to be annoyed, by someone, again, the client, asking about why work isn't being done when you know deep down it should be. So the attorney-client relationship starts to get under some stress and pressure, and it's your own doing. You're creating the problem. Now, sometimes people, in terms of lawyers, will not say no because they see it as disrespectful or rude. Well, I don't get that. Certainly, how you say no could be disrespectful and rude, but saying no in itself isn't necessarily that at all. I mean, while I sincerely appreciate your continued loyalty, my legal judgment tells me that you will be best served by my assisting you in finding an attorney with the level of experience this particular matter calls for. What's wrong with that? Nothing. I have been into many, many practices where it's kind of crazy in terms of just workloads. Learn to delegate. And boy, I could do a whole presentation on delegation. But you don't have to do this all by yourself. I one of the things I like to say, and some of this is in your written materials, relief isn't spelled ROLAIDS. When your practice is out of control, it's spelled DELEGATE. Boy, do I truly, truly believe that. So, but also, you can put some parameters around your practice, and let's talk to the clients about this. But, you don't have to respond to text messages 24/7. The same is true with email. At the beginning, that's let clients know. And I'm not a fan of text messaging. Man, if I were back in practice, there's no way in heck I'm giving everybody my cell phone number. That ain't happening. But that's me, okay? But it's okay. You can say, here are the times I return phone calls. Here are the times that I'm setting aside because this is when I'm most productive, and at these 2-3 hours in the morning, whatever it might be, or I'm not to be interrupted, and this is when I do my substantive work and really dig in. Staff are given permission to enforce these rules, and we're very respectful about them, but we're consistent too. It is okay to prioritize you. There's nothing wrong with that. I don't see that as selfish. I see that as self-care, and there's a huge difference. So, just some thoughts. This is really, really important. Again, it's about trying to prevent the true cause of malpractice. And oh, by the way, a lot of disciplinary issues. Maintain a written record of the advice being given in the decision-making process. I will tell you, we have been around for a lot of years. We've looked at a lot of client files, from attorneys, and it's extraordinarily rare to find sort of this perfect file. I don't know if it exists. There's some lawyers that get really pretty close and fairly consistent in what they're doing. There's a lot that's not so good, not so much. When we think about how a thorough, properly documented file, what does that mean? What does that look like? It's this. It's maintaining a written record of the advice being given in the decision-making process. That's one of the reasons why we say, even keep draft documents at times, whether it's contract, estate planning, et cetera, because that can be the record of the decision-making process and the advice being given. You don't necessarily just throw all that out at the end because we've closed the file. But let me share a couple of key places where you really want to think about this. Client-driven limitations on scope. It's about saving some green often and unintended consequences of the problems. So a client may say, I want to limit research. I don't want to pay for all that. I want you to rely on work done by somebody else. I don't want to pay for these experts, or I don't want to have the property appraised. I mean, the list goes on and on. You get this, and I know you see this. You really need to inform and so document that the client has been made aware of the legal ramifications of the limitations they are putting on you. Okay? And let's document the reasons the client shared for limiting your scope. They didn't want to pay for it. Okay. Because what happens is if they are harmed by their own stupid decision, and you may have told them something, but is it in writing? And if they're harmed and it's not in writing, if this is your fault, they're going to point the finger at you. Oh, how do you defend against this? It's word against word. You lose in most of these situations. Word against word, that's not what lawyers want to find themselves in when it comes to malpractice. I had this call last Friday, 2 business days ago. And we're talking about what to do when a client was refusing to follow the advice. Here we need to go even a little bit further. Document the client is aware of why you are making the recommendations, the benefits of following your advice, the potential fallout for not following your advice, and again, the client's stated reason for ignoring your advice. And the final is something I call the comfort trap. A lot of lawyers do a really good job of documenting files with problem clients and not so much with files that belong to really good clients. And this could even include family, friends, people we have a lot of faith and trust in terms of personal relationship. I got it. Here's the reason they start to get lax is because there's this belief, which is unfounded, completely unfounded, that these people will not sue. That's not true. This is a very litigious group. And one of the reasons why is kind of interesting. Lawyers say these people won't sue based on the faith and trust in terms of the personal relationship. But when there's a claim or a misstep, I should say a misstep that could lead to a claim, you know what they say? Based on the faith and trust in this relationship, you would never allow any harm to befall them. They expect you to work with them to help them get a recovery. And here's the rub. Sometimes lawyers do. I call that insurance fraud. Be very careful. Document your files. Okay? Document all files. We need this written record. Now, I did some work for my parents a number of years ago. I will share, I did not use all my normal documentation. I didn't have this long contract and on and on. I did document, though, the advice being given in the decision-making process. Wasn't worried much about my parents. I was worried about, because my world, you never know. My brother and sister, I know they're really good people. I'm not trying, but, they were in the room hearing what mom and dad were deciding and doing, and their brother is the one helping mom and dad do all this. So I'm going to make it very, very clear. So, okay. Make sure to keep the status of all files current. Obviously I would hope it's self-evident that this is extraordinarily important for solo lawyers, but it's true in any practice. The reason is in the event of an untimely death or disability, your successor or a partner, solo versus firm, is going to need to review client files in order to make quick determinations as to whether any immediate protective action is necessary. Mistakes can and will be made with poorly documented files, and we've seen claims come out of both situations, solos and law firms. Okay, it's also helpful to maintain a current office procedural manual that discusses calendaring system, conflict system, active file list, etc., so that any successor can expeditiously come up to speed if and when necessary. And of course, all critical systems, think calendar and conflicts, need to be kept current. The problem is we don't ever see these things coming. Who does? And we have a lot of this intellectual capital in our head. We know what's going on with all our matters. But what happens if you're not here? Now, you might be in the hospital. I'm not saying it's necessarily a death here. But if that intellectual capital isn't available, that's why we need to keep files current. And I would say this is ethically mandated. We don't have time to kind of get into that whole argument. Doesn't really matter anyway. Send monthly detailed billing statements. It's about helping your clients pay your bills in a timely fashion. Always bill at least monthly. This is what I would encourage you to do in terms of risk guy, unless I guess if a client specifically says I don't need to have it every month, okay, that's fine. But you want to try to avoid these surprise bills. That's one of the things. The key to successful billing and collections, in my mind, is having regular bills, but also providing some detail. And I when I say detail, I'm talking about telling your story. There's a difference between saying, having this entry 2 hours for research. Oh, okay, I don't know what the heck that means. Versus 2 hours of researching state case law on piercing the corporate veil. We start to tell the story. I am more likely, as a representative, kind of just consumer of legal services, to pay a bill that I understand what I am getting. What am I paying for? Tell the story. Okay. Now, I also like regular billing for this other reason. Verizon, the cable bill, the mortgage payment, the utility bills. We get billed every month, and we know something doesn't have, it's not good if we start to get behind. Okay. Well, if you're not sending bills out on a regular basis, you're giving this message that collecting the money you are owed isn't that important to you. So if it's not that important to you, why am I going to rush to pay you? You see where I'm going? Be consistent, okay? Be consistent and thorough. Tell your story. Really, I'm telling you, you can make it easy for clients to pay. They're not going to necessarily all be jumping on the bandwagon. Oh, thank you. This was one, but it helps. It makes a difference. Review all outgoing documents for accuracy. Here's one example. An attorney attempted to have computer-generated papers served on an individual at a personal residence, and service failed. The attorney investigated further, learned of, and verified an accurate work address for the individual, and attempted to serve a second time. The papers were reprinted and sent out for service, unfortunately, with the old address, because the work address was never entered into the firm's database and no one double-checked the papers. Deadline ran. Oops, little things matter. You really, really need to check the accuracy and content of outgoing documents. Think letters, substantive email, briefs, contracts, motions, and it goes on. I'll even tell you, here's one interesting story. This happened a number of years ago, but we at ALPS, we hire a lot of defense lawyers, right? I mean, that's again, I would think self-evident. We had a situation where a bill came in, and there was again, all these different line items, and one of the items was a bill or a charge, if you will, for a lap dance for $200. You can't make this stuff up. The claim, if you will, there was no reason for a lap dance. This had nothing to do with anything. The claim was complete. It's just, but there's this charge. I assure you, we stopped doing business with this firm. If things like that, no, absolutely not. Cannot, should not happen. Review, okay? It's absolutely essential in my mind. And I'll share that even, poor spelling and grammar can be a problem. What is the unintentional message being sent? And sometimes I think, okay, we play some of these texts, fat finger syndrome or whatever we call it, fat thumb syndrome, and, but you get a lot of misspellings. And you really do, if I start to see stuff like this, I really do start to say, I start to have concern. If you don't have time to even double check your communications to me, and it's consistently poorly written, I start to wonder if you have time to do the substantive work on my matter. I mean, that's a normal response. We can give, what do they say? Is it 90% of communication or something like that is nonverbal in terms of what gets communicated, and so many different types of communication exchanges, whether it's internet, based or conversation person to person. So much is shared nonverbally. What nonverbal messages are you giving that you really haven't stopped to think about? So, next, complete all matters in a timely fashion, because, again, procrastination is the enemy. I've always been surprised by this. How many claims, percentage-wise, you know, do you think are a result of procrastination? Um, I would have guessed very, very, very little. But it's actually it runs around 3.5%. The new latest studies out. I have yet to see the latest numbers, but the last study out of the ABA that all the carriers, and I shouldn't say a lot of the carriers, participate in supplying all sorts of data. It's about 3.5%. Personally, I felt like that was really quite high. All I can do here is to say we need to be cognizant of the problem. It's so easy to do. I'm going to be really honest and say I'm a procrastinator. I really am. And, I've gotten away with it so much. You start to get this, and I'm going to admit it, it's a false sense of comfort because I've gotten away with it so much. But in my world right now, if I blow a deadline, it's not somebody's, it's not their personal injury matter. It's not the statute of limitations date. It might be a publication date, and I can change that. And I get proud because there are times when I perform at my best under pressure, and I will let myself get into these situations because I know I tend to write better. I'm more effective with my critical thinking and that kind of stuff. But again, it only impacts me. We can't do this as lawyers because I will tell you, and I have missed things and I've had consequences. Some of them haven't been the best consequences, but again, it's not some $1 million loss. I assure you, I've made mistakes and missed things at times. So I want you to hear and understand there's a false sense of security here. And I just encourage you to recognize when it's happening and try to do something about it. If it's delegating some work, if it's changing your schedule, sometimes it could be as simple as just coming in the morning and doing, and I do this at times to myself because it does work for me, and doing the one thing that I've been procrastinating because I just do it. I'm fresh and just get it out of the way. And then it's amazing. The rest of the day is a lot easier because I'm not worrying anymore. Gosh, I got to get to this. I got to get to this. I got to get to this. I spend so much time ruminating, that's not helpful. So address it, deal with it. Okay. Document the conclusion of representation with a thank you letter. I got to tell you, I have an entire 60-minute program, and I could even go longer, on documenting scope up front and thank you letters. They're that important. I could tell you all kinds of reasons why, but let me just hit a couple of high points here. One of the things that I hear so often is they don't want to use them because we view these closure letters as a kiss off, a goodbye, get out of here, if you will. Come on, really? Someone turned over their legal issue to your competent hands and entrusted a lot of faith, confidence in you. Why, good Lord, would you not want to say thank you, honor and respect that? This concludes our representation of you in this matter. I hope you found our work to be exemplary. It has indeed been a pleasure. I look forward to working with you in future if and when the need ever arises. If you have other matters open, I'll see you next week, Mark, on the Jones case. Again, right to your audience. I've worked with firms that are so consistent and committed to thank you letters, other than a web page, which you have to have nowadays for all kinds of obvious reasons. This is the only marketing thing they do. There's no billboards out on 95. There's nothing in the, it's thank you letters, and the referral and repeat business is through the roof. Why would you not want to do that? It's an incredible marketing opportunity. It also can start the statute of limitations clock running, and that's another big issue. In a lot of claims, and we do see claims come up on work done 5, 10, 15, 20, even 30 years old. There have been some cases out there even older. And, there's this doctrine of continuous representation that can be a real problem. Well, if we have the consistent ongoing use of closure letters, that can be the bright line this starts the statute of limitations clock running on each of these discrete matters. I'm telling you, that's powerful stuff. That's really powerful stuff. The final thing that I'll say about these letters, and this can also be a significant issue in terms of both ethics and malpractice. An interesting question will come up from time to time. So we're looking at perhaps a new matter, and we have this hit. If we're in Rule 1.7, the current client rule, we can't stay in. If we're in the past client Rule 1.9, which is a little more permissive, we can. Ethically, whether or not it's a good idea, we have to work through that too. But ethically, we there are times where we can. Well, what gets you from 1.7 to 1.9? Lawyers are constantly saying it's the passage of time, or there's some bright line out there: deeds delivered, contract signed, judge signed the final order, settlement been dispersed. It goes on and on. I've read the rule in all these jurisdictions in the ABA. There's no language like that anywhere. It doesn't count. That's irrelevant. There's one thing and one thing only that converts someone from a current client to a past client, and that's this letter of closure. This concludes our representation of you in this matter. So, for conflict resolution purposes, if you are not using closure letters, whether it could be an email, if they don't have to be thank you cards, whatever you want to do, I don't care. But if you don't have this documented, when you are looking at conflict resolution issues, in the absence of one of these letters, you are in 1.7, the current client rule. View them as inactive current clients, because that's typically what they think. They view you, and that's what we want, isn't it? We want clients to view us as their firm or their lawyer, so they will come back. But you don't get it both ways. So, I would send a letter out. I'm going to say, we're done. Hope you found our work exemplary, et cetera, and I'll, feel free to come back anytime. That's great. But I've documented everything's closed and I'm done on what I was doing. So extraordinarily important. Keep a complete copy of the client file for at least 7 years post-closure. Why 7 years? This is one of the most common questions that comes in over the years. How long do we need to keep these closed files? And there's all kinds of rules and, a couple of ethics opinions that sort of skirt around the issue a little bit. But where I come down is there are going to be some exceptions, but in general, here's how I come at it. How long is the statute of limitations running on malpractice under contract law? And in a lot of jurisdictions, we're talking 5 or 6 years. We add a year for good measure. You want to keep these files because if you're ever sued, if you don't have a file to defend yourself with, we've got a problem. And I've heard lawyers say, we don't keep this stuff. The client has it, and good luck getting it from them. And even if you do, it may or may not be the complete file that you gave them originally. That key email, that's missing. I don't know what happened to that. But sometimes lawyers will say, well, we don't keep this file. And I never understood, that will help even prevent these suits. I have no idea how the rationale of that one works. I got to tell you, no. They don't care if there's a file or not. So keep it 7 years. Now, there are going to be some exceptions to this, obviously. Your tracking basis and property. If the files in regard to a minor and after 7 years are still a minor, capital crimes, estate plans, there's going to be some exceptions. We need to go quite a bit longer. That 7-year rule is pretty important. The other thing that I want to just underscore here is, you'll note I said keep a complete copy. What does complete mean? I want to underscore, going back to we need a record device being given and decision-making process. We have to have all substantive email, substantive text messages, drafts to the degree that they help us get there, as I talked about earlier. And we really do need to say this and underscore it, because a lot of times firms will have this process where the a bunch of the information of the file is digital and in this digital file, but the email and the text stay in other systems. And when we close, they never get pulled in. We've had situations where the file will come in and say, we're still trying to find the email. Okay, please let us know. We need that because there's a lot of information missing here. And so, yeah, we know. We're just trying to search through a 1.5 million email. We're having trouble finding it all. Others we've had say, well, unfortunately, we destroyed the tapes or whatever it might be that this email was on. We did an upgrade or we're running out of space, so we don't have any of it. Okay, now we got a problem. So please keep a complete copy. And if at the time of closure, it's not complete, that's the time to gather it all because it's going to be a lot harder later on. Okay, avoid suing for fees. I love this. I keep back this towards unpredictable. Boy, is that true in this space. Try not to go here. You know what carriers say. This is a fast track to counterclaims. There are some carriers out there that if you do sue for fees, they will not renew you. Or if you tell them as you're trying to get underwritten for the first time that you sue for fees, they aren't going to underwrite you and just, good luck, go elsewhere. They're not interested. That should tell you something. I will share that I kind of break ranks a little bit with the industry on this one. I do believe that lawyers that have gotten good work and good outcomes really do deserve to be paid. But making a decision to sue for fees based on that is a misstep. I don't care if you got good work. And I really do agree that you deserve to be paid. That's the wrong question. The question goes back to something we talked about earlier. Can they afford to pay the bill? Do they have the money? They may have had at the beginning, but circumstances change, jobs get lost, unexpected illnesses, all kinds of things. They may or may not have the ability now. Maybe they could never afford you to begin with. The question really needs to be, can they afford to pay? If the answer is no, walk away. Now, I've had this discussion, but Mark, it's $3,000. I've had these discussions so many times. It's $3,000. Okay. It's, you're going to put your work under a different lens where it's perfect. Okay. The malpractice lens is a different world. Okay. I would have your file reviewed before you make a decision to sue for fees by somebody just to see if they were going to sue you on this, where were they going to hang their hat? Let's make an informed and intentional decision here. But it's time. I'm just saying, I don't think it's worth it. I would walk away. I really would. I've had this other discussion, but Mark, it's $100,000. And my response in that situation, I've had this more than once too, but this was really appropriate for this particular circumstance. I said, look, if you are crazy enough to allow somebody to get into you for $100,000 when you knew they couldn't afford to pay the first $1,000, you need to run as fast as you can away from this, and you need to change your business model because this isn't working. Okay? You have to understand that when people are upside down and with their legal bill, there's a lot of resources out there and a lot of people that'll tell you, what you do? You counter sue. Lawyers will typically take 50 cents on the dollar, even a lot less. And sometimes this is even intentional. And you have all kinds of headaches when these claims come up. So I encourage you, that's really work to try to get the bills paid and make sure that we've fully determined that they can afford our services before we even get involved. And then try to have these discussions, work on payment plans if necessary in there. But, if you have to sue now and again and the money's out there and your file's tight, honestly, I wish you luck. One of the things you could do is depersonalize it, have another lawyer in the area bring that suit. If it's you and me, it's very personal. If it's somebody down the street suing me, I get it. These are the consequences when I'm trying to stiff my lawyer. Or if it's ethically permissible in your jurisdiction, you could turn it over to a collection agency and just avoid the headache. So there's a couple of additional thoughts. Politely decline to give legal advice to all 9 clients, regardless of the setting. We're really talking about the accidental client situation. Here's a real claim. We had a situation where an associate was at a social function, and a number of people there of all walks of life, and somebody else learned that there's an attorney here and entered into a conversation, and it was about a personal injury situation, and the lawyer was basically saying, we don't do personal injury, so we really can't help you. There are a number of good firms here in the area, and gave a couple of names, and I have no problem with any of this so far. And then she stopped and said, but be aware, in this jurisdiction, there's something called a statute of limitations, and it's 2 years. So we have a little bit of time left based on what I'm hearing. I mean, we've got more than a little time. So I think you're fine, but you really don't want to keep waiting. You want to go get some help. Left it at that. Wasn't 2 years. It was 6 months. And we were right up on that 6 months. She didn't understand the exceptions, had no clue. By the time the lawyer got to the firm, the statute had run. There's a malpractice claim that comes back, and there was a full loss paid. And we said, well, Mark, there's no money paid. I didn't intend, there's no fee agreement. I didn't intend to establish an attorney-client relationship. And my response is, I don't care. What does that have to do with it? It's not about you. That's why we call them accidental clients. If it's reasonable that the person you're interacting with is responding to the exchange, wherever it is, courthouse steps, backyard fence, I go on and on about settings. If it's foreseeable and reasonable that this person is responding to the exchange is if they're receiving some advice from a lawyer about their legal issue, and it's foreseeable, reasonable, they're going to rely or act on this advice in some fashion, we're pretty much there. Just saying, heads up. Accidental clients can be family members, extended family, members of church, your church group, friends, corporate constituents, beneficiaries of the estate, prospective clients, unrepresented parties. List just goes on and on and on. And all of those categories that I've just shared are claims that we've seen. Every carrier has. These are a little more common than you'd expect. Okay. Document all co-counsel and local counsel agreements in writing. And really, the thing I'll say here, I encourage you to make sure that you establish very clearly the roles and responsibilities of each attorney, particularly if your role is going to be somewhat limited. For instance, let's say you and I enter into a situation on a personal injury matter, and I'm just going to be trial counsel. We have to have an agreement that's very clear. I will only be involved if and when this goes, we need to file a suit and goes to trial. And we should share that with the client so the client understands I'm not involved at all unless and until we file suit. Then I'm going to rock and roll. We've had situations where the primary counsel, again, blows the statute, and then is underinsured or no insurance, and then they sue trial counsel, who's co-counsel, but there's no documentation again. At co-counsel, you're fully exposed for each other. You're kind of entering into this partnership for this one legal matter. And unless you put some parameters around that, you got some issues that could be really significant if something goes south. So I encourage you, make sure you document roles and responsibilities in these agreements. If you haven't already done so, create a succession plan and designate a successor backup attorney. Again, this is not limited to solos. I can tell stories. We don't have time to get into the big ones, but where that's been a problem even in firms. But a quick one that I will share, an attorney was injured in an accident and ended up in a coma, and solo attorney, and she had hired a sort of a part-time receptionist / secretary that had no legal background at all right before this happened. And here, this poor woman, receptionist, just dealing with calls, what's going on in my matter, and all she knew to say was, I'm sorry, Miss Jones is in the hospital, she's in an accident, it's in coma, it's pretty serious. I don't know when she will get out. I will make sure she gets back to you as soon as she's better, and this went on for well over a month. Eventually, by the time the attorney got back, there were, I think it's either 5 or 6 statutes blown, and we had to deal with all of that. You know, you need to have a succession plan, designate a backup attorney. And I want to underscore, folks, the role of a successor attorney or backup attorney is not to step in and take over a second practice. Good Lord. I mean, who can do that? No, it's to help the transition, to wind up a practice, or to be there as a backup, for the week you're off on vacation, and just there for emergencies. That's understand what the ask really is. And I hope that can help make the ask. But then I also hope that if you are asked, you would be open to saying yes. And a final comment here, there's no rule that says you have to have one successor or one backup attorney. I've seen situations where a group will do this for each other. You come together as 4 or 5 lawyers. Now we have to think through the potential conflict issues and whatnot, but it's doable. Share the load. This is not optional. More and more jurisdictions, this is mandatory, particularly for solos in terms of the ethical rules. Okay. And finally, in case you missed it the first 2 times, find time to take care of yourself and your support systems. I hope it's become obvious. This is the true cause of malpractice. And I get asked, and I've been at this for over 26 years now, and I get asked time and again in different contexts, Mark, you got a lot of great ideas and a lot of risk guys like you, all sorts of tips, law practice management, all sorts of, but what's the one thing? If there's only one thing, where do we get the most bang for our buck? Right here. If out of all this, you want to make no changes, okay, that's your call, it's your life, your practice. But this is the one I'd encourage you to focus on. It's about, we don't live to work. We work to have a life, mental, physical, emotional, spiritual, financial, all aspects of your life really need, I should say, wellness matters. Really focus on that. Nurture your support systems. Unplug from the matrix. When I used to live out of Montana, just because I go up the High Line, which is an incredible, beautiful trail up in the high country of Glacier National Park, and take a cell call doesn't mean it's a good idea. Nor should I do that. Would I ever try to do it poolside at Cabo? Come on. I need a break, and it's okay. Okay? Taking care of yourself isn't selfish. A final story that I will tell, and then we'll be right up here against our 90 minutes. Years ago, I had a very good friend who was a psychiatrist. Really an interesting, wonderful, wonderful man. And he had a hospital-based practice that was just out of control. And periodically, 3, 4, sometimes even 5 days a week, he'd disappear unannounced. Now, what he was doing, he would just go downstairs, cross the street into this little coffee shop at the hospital and get a cup of coffee, slow down, take his breath, and just relax for a few, and then get back to work. The staff knew. They never knew when it was coming, but they knew if they can't find him, they know where he is, and it's still spinning out. I'm not here to suggest that approach is the way to deal with your clients as opposed to patients, but I loved his thinking. What I liked about that and what I respected so much is it was his way of reminding himself whose life it was and who was in control. Now, he would never do something that would jeopardize a patient, but there were times when he just needed to remind himself, and you know what? God bless him. I thought that was awesome. So that's all I have. I hope you found something of value. I will share, in conclusion, some contact information here. While I am a risk manager, I am not hired by ALPS to be a risk manager of the corporation. I am hired by ALPS to be your risk manager. You do not need to be an ALPS insured. There's no cost to visit with me. If there's ever something I can do to assist with law practice management, risk management, ethics, how do these policies work? Can you explain malpractice insurance? I just don't get it. What's a tail? I'm happy to try to help out. Please feel to reach out at your convenience. So that's it. Again, there's some written materials. I don't see we have any questions. So, Nina, I'll turn it back over to you.
Awesome. Thank you so much, Mark, for the presentation and just letting us know about all of those ways, not only to avoid malpractice, but also just to have wellness in our practice. We really appreciate that. And then if anyone has any questions, looks like we've got about 3 if you want to go ahead.
Well, let's hit these real quick. How should I approach a situation where a client cannot afford my services, but I feel compelled to help? Well, you got a choice to make, assuming that this isn't shooting from the hip, dabbling, which we talked about earlier. Hey, go pro bono. God bless. Go for it. Make sure, because there's a coverage issue in play, just because work is pro bono doesn't mean it's covered. If you're taking on a pro bono entity's client and the services are delivered on behalf of them, that's a problem. For coverage to come into play for pro bono work, there needs to be an attorney-client relationship. The professional services need to be the professional services lawyers typically do, and they need to be a client of the named insured, which is your firm. Okay, so make these clients your clients. You want to go for it. I got to scroll here. Okay. What specific systems can I use to ensure I never overlook critical deadlines or miss important calendar entries? It's a great question, and one that's extraordinarily difficult to answer. And I don't mean to be sort of dismissive, but you have to use the system that works best for you. I have been in firms, and I kid you not, I was into a solo situation a number of years ago. We had spent money for 12 different calendaring systems, and he was telling me which one to pick. I said, well, which one are you going to use? I don't like any of them, Mark. It's not the system. It's the process. So I focus on process, and the system that makes the process most comfortable for you is the one to develop. For me, Outlook's perfectly fine. It's a great tool. I'm using, what do we call it now? Microsoft 365. And I've been using that for years and years. But I use that tool in a way that works best for me. How can I confidently assess when I should say no to a case due to lack of expertise without harming my client relationship? Ooh, okay. That's going to be difficult. I mean, I guess I sit and say, this is one of these situations where it's going to be a gut check to some degree. Do I have the interest in this? Can I come up to speed? Is the client going to be okay with my coming up to speed? Because remember, you can't bill just to go out and buy some new book and read, a crash course through a weekend or something, maybe you can co-counsel, get a mentor, as we talked. But, if you, at the end of the day, if your gut says this doesn't feel right, listen to your gut. I don't know how else to help on that one. Okay. What are the best practices for documenting declinations when I choose not to take a case on? Well, I'll tell you what. My email address again, mbass, B-A-S-S, at Alps, A-L-P-S, insurance, oneword.com. Email and say, because I don't know who you are. Email me and say, hey, Mark, can you send me a free, and it's all free, a sample non-engagement letter? I'll send you a sample non-engagement letter. You can see what the language tends to look like. But again, there's no magic. There's no critical writing. You have to have it say this. It's just, it could be as simple as the no that I shared. Well, it's not saying no, but even saying no like that in writing, whether it's an email or a letter, it can be just fine. What should my fee agreements include to avoid future disputes and ensure clarity with clients? I think we need to have a thorough discussion again of realistically what the range of costs might be. Particularly if we're looking at litigation or something. If it's flat fee, okay, that's fine. But that's make sure they understand. even though it's flat fee, there could be situations where we may have to have a little additional work done. What other things are they going to be responsible for? They need to be able to make a decision for themselves. Can I afford this or not? That's really huge. The other thing that I would add, because in my mind they overlap in some ways, again, it goes back, be thorough in documenting your scope. What are you going to do? What are you not going to do? Okay. How do I handle billing for clients in a way that is transparent yet doesn't harm the relationship? Um, I'd love to sit down and talk with you, Mark, because I'm not quite sure where you're going with that. The best thing that I can do is to say, and I just love the description. More and more people that are writing on this topic sort of talk about it in this way. That's share the story. Try to just set forth. I don't care how you do it, short little narrative, or if you're using some software that just again, there's a difference between 2 hours of research or something, but do what you can to demonstrate the value that the client received for the amount of the money you are charging them this month. Tell the story. That's that.
Awesome. Well, thank you so much, Mark, for those additional insights. And thank you all so much for asking your questions. We want to thank you all for joining us for another Justia webinar. I want to remind you all of the benefits of upgrading to Justia Connect Pro. We mentioned that CLE credit that you can get both for watching live and on-demand presentations. You also get access to our new Justia chat featured. It's AI powered and can help you connect with the leads that you want for your firm. There's also various other benefits like a pro badge on your directory profile, your ability to feature reviews, and access to our $200 Justia Connect Pro credit, which can get you discounts on other Justia marketing services. To learn more, you can go to pro.justia.com. Have a wonderful rest of your day. Thank you so much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.